how they are empowered to secure evidence of detriment, because I would imagine, at least upon application, a new charity would present the benefits and the public benefits it has. It may be, it may not perceive itself, or it may be quiet about any potential detriment, and unless that was in the public domain or in the awareness of the Charity Commission in the England and Wales, I don't know how they would become aware of the detriment perspectives.
Well, this goes back to Senator Cameron, and Chair, for now I'll finish up on this. I'm concerned about time constraints, but that's the problem, isn't it?
Asking questions, Senator.
Sorry?
You may continue.
Right. No, Chair, thank you, Chair. Just, I know that Senator Cameron had that look in his eye. But can I just finish off on that?
You know, it's your...
But that's the problem, isn't it? That you go through this process of assessing whether an organisation gets a tax-free status, which all of us who pay tax in effect pay for, I mean, in a sense, and the public policy intent is a good one, and if it's a charity, it does things that others, broadly speaking, I think one of our previous witnesses yesterday said that it's the sort of thing that if that charity didn't do those good works, government would have to pick up the tab. That's one way of looking at it, and it costs us all more money. That was one perspective. But at the moment, isn't the ATO hamstrung in the sense that you tick the boxes as to whether it complies with the tax-free requirements to get its tax-free status, but you're hamstrung after it gets, for instance, after it gets assessed as being tax-free, if you are then presented with allegations of abuse, of corruption, of fraud, what protection is there for taxpayers then, other than what both you and Mr. Wilcock said, I think quite fairly? You gave an exposition of what is occurring now. You're basically saying that, you know, if there are criminal charges laid or criminal findings made, or if there's a court case against that organisation in the civil courts, short of that, it's business as usual.
Not necessarily quite true. A endorsed charity may start undertaking activities that are not charitable, and that's the most common reason where we review them and, if necessary, remove their charitable endorsement.
But how? What do you do? Do you actually investigate them? Do you audit them?
Yes.
You don't have much resources.
But the audit, but as I said, we can, if necessary, for a involved review, bring in other resources from the tax office more broadly. But typically that review will be that the pursuit of their charitable purposes they've strayed from charitable purposes. They're pursuing private benefit or other things which are clearly more consistent with the expertise of the tax office to draw conclusions about, as opposed to matters of criminality perhaps.
So, for instance, the letter I wrote to the Taxation Commissioner about COSRECI, the Church of Scientology organisation that's based in South Australia, I'll only know about any response if there is a public response from the Tax Commissioner. That's the protocol, isn't it?
Well, without discussing a particular taxpayer, I'm sure that the Commissioner will respond to your letter as best he can without breaching, again, the secrecy provisions. If your letter did result in any change of the charitable status, for example, the status of the organisation, you should perhaps only be aware through public record evidence.
Thank you.
Before we move off this, Senator, I've just had the benefit of being able to flick to another page of our submission and spot some material that might assist. You drew attention to that particular sentence on page 7, but as you would know, the relevant provision in the bill that probably helps illuminate this somewhat relates to proposed paragraph 50-5 to 2b, where in the bill it says the public benefit test must include the following principle: the benefit must be balanced against any detrimental harm. Now, that particular provision is discussed for about half a page on page 11 of our submission. It notes that at the moment the weighing of public benefit against public detriment or harm is not required. I would have added, now that I read it again, in all cases at the end of that sentence, because the paragraph goes on to note that the ATO advised that these considerations are at times taken into account. The difference, in other words, I think, is that what we're saying is that at the moment under the common law it is not necessary to weigh these issues in all cases, but the bill, the second paragraph under that heading on page 11, the bill would require an explicit balancing of public benefit against detriment or harm in all cases. So there is an issue, I suppose, as I mentioned earlier, there is an issue about the extent to which the existing common law in relation to public benefit, which we understand has been preserved by the relevant legislation in the UK, and which, again, the material on page 11 sort of highlights that the UK Charity Commission has produced guidelines about how it will interpret the public benefit and how it will apply it, and note that there are cases where the detriments are significant and therefore will actually have an impact.
Although, Mr Wilcock, and I appreciate that, but I think that Ms Edwards from the UK, the Charity Commission of England and Wales, did say that detriment and harm question is part of our public benefit test as one of our key principles of public benefit, and went on to say more. So the factor seems to be that they do look at detriment.
And that being the case, then I think it really does become a question of administration. It may be difficult for the ATO to say exactly how it would interpret, how it would apply this particular test, because, of course, the test itself would still need to be formulated and put into regulations before the ATO would actually be able to say exactly what the
You can see my point in that the approach, the practice in the UK looks at detriment in weighing it up.
Indeed, but as that particular material on page 11 was seeking to point out, and which indeed Mr Hardy has also been saying, in many cases it will be very difficult for the Commissioner to, without making very active inquiries in all particular cases, which in and of itself would then have fairly significant resource implications for the ATO, it will be difficult for the Commissioner to have any material going to the alleged detriment or harm that might be created by an applicant. And so the bottom line is, in one regard, depending on how the test is formulated and then how the ATO go about administering, in one sense it might be an extremely resource-intensive requirement for the ATO to make active inquiries in relation to every application to determine whether or not there is any detriment and harm. On the other, you might end up with a situation where, again, unless something is already known to the ATO, it effectively simply acts on the basis of the information that's already in its hands, and unless the relevant applicant actually highlights the detriment or harm that it engages in, it may not, the ATO may not be in any better position than it is already at the moment.
Or Mr Wilcock, it could be a case, and I understand the issue of resources, but I think the UK and the New Zealand Charities Commission made this point, that if it's a complaint-based mechanism, rather than trawling through every organisation saying what's the detriment here, but if there is evidence given, if there's information given that points to harm, then surely the ATO should have the adequate resources to appropriately assess whether there is harm that should be taken into account. I won't take it any further than that. Thank you, Chair.
Thank you. Senator Cameron.
Yeah, thanks. Mr Hardy, you indicated that religions self-assess. Is there a form that you fill in?
No, Senator. As long as they don't seek charitable endorsement, self-assessment is that you self-assess. There's no form, there's no interaction necessary with the tax office.
So you just say, I'm a religion?
I'm a religious organisation, and I therefore see in the tax legislation that if I am that, I am exempt from income tax. I don't therefore need to lodge an income tax return form, and on the assumption that the organisation has no other need to interact with the tax office, they wouldn't have any interaction with us.